Shanks.
Thank you, Mr Speaker. It's my pleasure to stand and support this bill tonight in the House. As Chair of the Social Services Select Committee, I can say that we had a substantial debate within this committee, and many issues were raised with our submitters when they came forward, and because of some of the issues, changes were made to the bill, because you don't always get it 100% right when it comes into the Select Committee, and we listened to the submitters and we made changes accordingly. Tonight I'd like to acknowledge the officials who put in a lot of work into this bill. They came back many times with many new answers for us as we dug deeper and deeper, and the committee appreciates the hard work that they put in. And also I know they did work out of their normal hours to come and support this bill as well tonight. The bill actually received 51 submissions, which ranged from the Youth Court of New Zealand, the police, Law Society and many NGOs. And a huge criticism of the bill in the Select Committee that there was no evidence-based research to support the changes made in this bill. And the fact that there has been little evidence-based research undertaken in New Zealand around youth offending in the programs is no reason to make a change. Otherwise we would be waiting forever to make a change and make a difference in these children's lives. So because of that, status quo is not good enough for us. We have to make changes. There was no choice. In fact, in an article at the end of this year in the Don Post on the 5th September in 2009, Judge Andrew Beecroft put some very important facts out there about the youth that he sees in his youth court. And if I can just give you some of these facts, and they are pretty sobering. 85% of those appearing in the youth court are male. 80% are not at school. That's not truancy. That is entirely out of the education system. 80% would be alcohol and cannabis problems. 50% are Māori, and in some areas that's up to 80 or 90% of the youth before the youth court. Judge Beecroft went on to say he sees a lot of family instability, a dad who is long gone, a mother who is struggling. 1 in 3 kids will undergo a psychological assessment, and many go on to further assessment, counselling and treatment. In fact, he went on to say there has been no New Zealand research done, but based on international evidence, about a quarter of teenagers who appear in the court have symptoms, sometimes obvious, sometimes subtle, of fetal-alcohol spectrum disorder. Nobody really understands how seriously damaged a lot of these kids are. That is Judge Andrew Beecroft saying we have a major problem in New Zealand, one that needs to be addressed. And Labour sits there and say it's too late. It's never too late to give up on the children of New Zealand. And it might have been in your basket and too hard for that Labour government, but for this government and this minister, she is not going to give up on the children of New Zealand, and that's what this bill is actually about, those youth. So the status quo for a national government just doesn't work. So what about the purpose of this bill? Let's get right back to why we have got this bill here. And a big part of the bill was about 12 and 13-year-olds going into a youth court. But it's important, if we're going to do that, that we have protections for these children. And it's important that we have to strengthen the youth court, give them more tools so they can treat these children when they get there. Give them tools for sentencing, measures for dealing with offending, addresses the causes of underlying this offending. Something which the Labour government didn't understand. It's actually about addressing the underlying causes of offending. And that's what this bill helps to do. And if you read the bill, you would see that it's in there. Many submitters agreed that the bill is addressing areas of high and complex need. It's aimed to increase methods of accountability of young offenders, increase assistance for young offenders, improve and provide tools to the youth court. The greatest concern with the bill by some of the submitters was the extension of this jurisdiction of 12 and 13-year-olds. We must remember We are discussing and looking at the most serious and persistent young offenders who cause significant harm to themselves, others and their communities, and for whom the present system is not sufficiently intense. To expand on 12 and 13-year-olds charged with serious offences is important to this government. So we also have to give the youth court some tools, more tools so they can deal with these offenders. And those will involve things like longer supervision with activity order, longer supervision with residence order, because 3 months just honestly doesn't cut it. Early release from supervision with residence order, military-style activity camps. A range of new orders will be introduced, including parenting education program orders, mentoring program orders, alcohol or drug rehabilitation orders, judicial monitoring, intensive supervision orders and breach provisions. Now I notice that the Labour members aren't arguing about these new tools because actually they're good. And actually they are strengthening the youth court because the big argument about the youth court was they had no tools. And we're also going to improve other existing orders, such as, pretty logical, measures for dealing with offending by a child or young person should be, so far as practically to do, address the causes underlying the child or young person's offending. Removal of consent to community work orders. Now that would be pretty logical, wouldn't it? What offender, when you say to them, we'd like you to do a community work order, but you have to agree to it, would actually want to agree to it? So we're going to remove that. Split sentencing, review of orders for periods of at least 8 months, social worker reports, access to reports and plans. Actually, pretty logical stuff. I want to speak more about the most controversial aspect of this bill, the military-style activity camps. 27 submitters opposed having the military-style activity camps in the youth jurisdiction. Military-style activity camps will cater for the most serious young offenders on youth court orders who require intensive 24-hour supervision, a structured environment, and a complete package of support to address the causes of offending. Long-term mentoring will be provided, along with help with literacy and numeracy skills, something that the Labour government doesn't think we're failing at. Well, in fact, I can tell you most probably a lot of these children haven't got good literacy and numeracy skills. Most of them have dropped out of school, aren't truant, aren't even in the education system. And for programs to address drug or alcohol problems, the program will include a period in a military-style activity camp, a structured program in a residential environment, and supported transition back into the community. There will be a focus on installing self-discipline, personal responsibility, and community values. Actually, just looking at that in itself is what most parents do. We instill self-discipline, personal responsibility, and community values in our children. And it's unfortunate not everybody does that in their own family, or in their wider families even, because if they did, then maybe we wouldn't have so many offenders now. People actually taking responsibilities for their own families would be a good thing. Military-style activity camps may represent the last opportunity for some young offenders to turn their lives around after being dealt with in the adult criminal jurisdiction. Child, Youth and Family is working with New Zealand Defence Force and an NGO provider to develop and deliver military-style activity camps. The Defence Force has a proven experience in helping young people to gain important life skills, self-discipline and employment through its Limited Services Volunteer Program. In fact, I've recommended that to some of my constituents and they've had some great success stories. There are to be 40 available places on military-style activity camps, so we're not talking about a lot of places, we're talking about a few. The program being introduced will differ from the previous corrective training sentence and some other military-style models used in other countries. Mr. Speaker, the legislation is well overdue. I commend the Minister on her courage to face some of the hard issues that confront the youth of New Zealand. It is my pleasure to support this bill tonight.